Hi everyone, my name is Rachel Marks and I'm the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible Chad Michaelson, a Pennsylvania construction lien law guru. Today's webinar's topic is, what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous Chad Michaelson.
Well, thank you, Rachel. That's quite an introduction. My name is Chad Michaelson. I'm a partner at Meyer, Unkovic Scott, a law firm in Pittsburgh, and I'm a construction lawyer. And the goal today is to talk to you a little bit about what happens after you record your lien and how do you actually turn that into money. Happy to take questions here during the webinar. And as you can see on this slide, there are some instructions for you to be able to put questions in the chat box, and we'll watch those and take a couple minutes at the end here and be happy to answer any questions that you might have. So what's the process of actually getting money in your pocket that you're owed? The lien is helpful in that, but it's really just a first step. A lien, we're going to talk about the difference between really three things here. The preliminary notices that you file in order to make sure you can get a lien, the lien itself, and then the judgment. The judgment is what allows you to collect money, but it too is just a piece of paper. So there's really a fourth step, which is actually turning your judgment into money, and we'll touch briefly on that at the very end. So the first thing I want to point out or talk about is that the lien law in Pennsylvania requires a number of steps, particularly if you are a subcontractor or a supplier, if you don't have a direct contract with the owner of the property. In that case, it's very important that you file a preliminary notice, and that's one of the things that SunRay helps you do. Those preliminary notices have to be served on the owner within 5 months after you complete your work. In Pennsylvania, you have 6 months to file a lien, but this notice has to be filed 30 days before you file your lien. So you have to get that done in 5 months. In other words, subs and suppliers have a shorter time. But that notice is not a lien. If you serve that notice and you don't follow up and actually file a lien claim within 6 months, you have no lien. So after SunRay has helped you to file a notice, you have to go take the next step of preparing and filing a mechanics lien claim. And there are very specific requirements for what goes into that mechanics lien claim in the statute. But once that's prepared and properly filed, and then again served on the owner of the property, if it's in the state, it's served by the sheriff. If it's out of state, there are other ways to accomplish service, but you have to take all those steps in order to get your lien. But the filing of that claim and the service of that claim only imposes a lien. It's not a judgment. So what's the difference? A lien is just a claim on the property. It's just something that is recorded that says that you have an interest in that property. Just like if a bank records a mortgage and somebody wants to sell a property, they'll see that the property can't be sold without dealing with the mortgage. So in this case, your lien will be of record. But that's it. It doesn't impose an obligation on the owner of property to pay you anything. So a lien doesn't get you the right to payment, but it does create leverage. It is the lien itself, this claim that you file, is just your side of the story. It's just what you claim is owed. So it can be challenged, and it's likely to be challenged by the owner. But before that happens, before those legal proceedings happen to challenge your lien, the mere existence of a lien can have a significant impact on the owner's financing and on the general contractor's right to receive payment under its contract. Owners who are working under construction loans, who are taking draws in order to pay their contractor, might not be able to take draws if there's a lien filed. General contractors who are applying for periodic payments in order to pay themselves and their subs are not going to be able to get periodic payments unless they can satisfy the owner that they've paid all their subs and suppliers and that all liens have been waived. So the mere existence of a lien gives you leverage to negotiate payment. And that's a positive because, as we're going to talk about in the next 10 minutes or so, the process of trying to get a judgment and then collect on the judgment is a long and costly proceeding. It's a full legal proceeding. So, and the owner knows that too. So once you file a lien, the owner or the general contractor knows that even if they question your lien, there is cost and time required for them to go to court to challenge the lien, whether they think you have no lien at all or whether there's a challenge to the amount or whatever it is. That plus the impact on the financing creates real leverage for the lien holder. And the idea is to get paid based on the filing of the lien and not to have to go through the entire proceeding to enforce the lien. So a mechanics lien complaint is the next step in the process. After you've filed your lien, after you've served your lien, after you have a valid lien on the property, in order to turn that lien into a judgment that you can use to get money, you have to file a lawsuit, which starts with a complaint. So we file a complaint to enforce a mechanics lien. And the complaint basically says, we filed a mechanics lien, it's properly served, it exists, and here's the amount, and we want the court to turn that into a judgment. That complaint has to be filed within 2 years after you file your mechanics lien claim. So you have some time while you have a lien pending to negotiate a resolution before you actually have to file a lawsuit. Of course, there's no reason to wait 2 years if you don't think you're going to get paid, then you can file a complaint immediately and start this process. The issue, however, is that a complaint proceeds just like a typical lawsuit. And so you will file a complaint. The other party will then have 20 days to file an answer. They might, instead of filing an answer, file objections, which you have to go address with the court, which might take another 90 days to get resolved. And then you get into the discovery phase, which is where you exchange documents or perhaps there are depositions taken to try to establish the amount of the claim or what's owed or whatever the issues are in the case. Once discovery is finished, there might be other motions that are filed with the court asking the court to dismiss the case or whatever. Ultimately, you're likely to proceed to an actual trial in front of a judge in order to prove your claims. And then after a trial, if you're successful and you get a judgment or you get an award or a verdict at a trial, the other side has the right to appeal it. And that's part of the process too. So as you can see, the idea of taking this lien claim that you filed and getting to a judgment that you can turn into money is a long, long and costly process. And very importantly, the lien law does not include an attorney's fees provision. So whether you have the absolute right to payment and you get every dime that you asked for in your lien, you are not automatically entitled to recover attorney's fees. So you have to factor in that cost. So if you have a lien and the owner offers you, 80% of the lien, you have to ask yourself, should I take 75 or 80% of the lien now? Or am I going to spend more than that to take this thing to judgment and try to collect? The other thing I wanted to mention, and it's on the first bullet point here, is about preliminary objections. The preliminary objections are a way that an owner or a general contractor can say either, you didn't have the right to file a lien, or your lien's in the wrong amount, or you did something wrong, you did some misstep. And the lien law here in Pennsylvania and really in every state is very tricky. There are many, many things you have to do. exactly as the statute says. And even a minor mistake will void your lien. So these preliminary objections are very common. And the trick with preliminary objections is that in the lien law, there's no time limit on when they can be filed. So if I am defending a lien and I know that there are problems with that lien, I will wait to file those preliminary objections until the lien holder's 6-month period to file a lien has run, so that they can't amend or change their claim to fix it. If you file a lien immediately, you have a 6-month period. If you file a lien in 30 days or 60 days, and I come in and say, oh, you did it wrong, you can say, oh, well, okay, fine. I'll just refile it because I have 6 months, and I'll file a new lien and it'll be correct and we'll be fine. The trick here is to let that time run, because once the 6 months is run, there are a few things you can't do with your lien. You can't amend it to change to another property if you named the wrong property. You can't change the party that you contracted with if there's a mistake in that, and you can't increase the amount of the claim. So it's very important to get it right the first time. These preliminary objections can be very problematic. And again, another reason that turning a lien into money is very difficult. So what's the other reason you don't want to litigate a lien claim besides your attorney's fees? Well, lien litigation has some limitations. The mechanics lien law is intended to protect contractors, people who supply labor and materials for construction. And so it gives you this unique right that nobody else has. If you have an ordinary breach of contract suit or an ordinary civil suit, you don't get a lien on anything until you get a judgment. A mechanics lien lets you get a lien immediately. And because of that, there are some limitations. It only allows you to get a lien for the value of your labor and materials. Now that's okay, that's going to be the bulk of your claim, but it's not always all of your claim. For instance, the Pennsylvania Contractor and Subcontractor Payment Act is a very important remedy for contractors and subs in this state. CASPA, as we call it, provides for that the owner or the general that doesn't make payment in accordance with the contract is required to pay interest and potentially attorney's fees. But you cannot include CASPA claims in a complaint to enforce a lien. You can only get a lien in the amount of the value of your labor and materials. You can't add in the interest or the attorney's fees. So there are some limitations, and what typically ends up happening is that if you have to pursue litigation to enforce a lien claim, you can file a separate complaint, a whole separate civil action, where you allege a breach of contract, a breach of the construction contract. You seek the amounts that are due plus your CASPA damages or any other kind of damages you might have under the contract that aren't for the value of labor and materials. There are some protections for you here on the other side of that, because the lien litigation is limited to the value of the lien. The owner can't assert counterclaims. But if the owner has back charges or something like that against you, they can use those claims to set off against your lien amount and reduce the amount that you might be able to ultimately lien or get in a judgment. And so the last step here, after you've gone through litigation and managed to reduce your lien claim to a judgment, is actually getting paid. So once you do obtain a judgment, you have to collect on it. The judgment is just a piece of paper. It's just recorded in the court in the county where it's entered, and it says that the contractor or the owner owes you a certain amount of money. There is a whole set of rules and a whole set of law around how do you turn that into money. Are you able to go and garnish the contractors or the owner's bank accounts? Can you find their bank accounts? Are you able to find property that they own and have the sheriff sell that property in order to satisfy your judgment? Those things are all a whole new legal proceeding on top of filing a complaint and getting to a judgment. So the enforcement of a judgment is also a complex, costly, time-consuming endeavor. You need to find the assets and convert these fixed assets that you find to cash. So the takeaway in explaining this sort of long and costly process of getting to money in your pocket is to explain why the filing of a lien and the leverage you create brings you to a sort of settlement posture that you need to seriously consider. So while in principle, you know that you filed a lien because you are owed 100 cents on the dollar for the work that you did. The reality is that if the owner or the contractor either can't pay or is refusing to pay, that you have to consider the time and cost that it's going to take you to try to get 100 cents on the dollar, because you're going to have to spend money to get there, and it's going to ultimately reduce what you recover at the end of the day. So you have to make a smart business decision up front about whether to try to resolve your lien without going through this entire long process. In some cases, it absolutely makes sense to go through with it. You know, there are cases where you have good CASPA remedies and you think you might be able to recover attorney's fees. So it makes sense to say, we are going to litigate this claim and we are going to get a judgment and we are going to collect. There are other cases where it certainly makes sense to settle early and just move on to the next job. But, you know, again, the overarching theme here is a lien is not a judgment, and it doesn't entitle you to put money in your pocket. It's a much longer process and much more involved, and it's going to require the assistance of an attorney and a lot of time and resources from your company. So I have about 3 minutes left in the 20 minutes here, and happy to take any questions. Otherwise, as you can see from the slide here, and maybe I'll turn it back to Rachel in a second, you can always reach out to SunRay with questions or to myself, and my contact information is below and Rachel's is above.
Thank you so much, Chad, for your time this morning and educating us on this very important topic. You provided us with super, super helpful and extremely valuable information. So right now, I don't see any questions that have come through, but like Chad just mentioned, if you think of a question even after the webinar, feel free to reach out to myself or Chad so we can make sure that we do answer your question. And let's see, if you'll just go to the next slide for me, Chad.
Sure thing.
Okay, if you guys want to take a moment to review us on Google, we would appreciate that. And then if you go to the next slide. Okay, so yeah, I want to get into our next webinars that we have with Chad. So that you guys can register at sunraynotice.com/webinars for the live webinars. Of course, if you can't make the live webinar, as you know, you can go onto our website and filter to these webinars by looking under the state of Pennsylvania. So our next webinar with Chad will be on Thursday, August 10th from 9 a.m. to 9:20 Eastern Standard Time. The topic will be don't sign a release unless it passes this checklist. And then the next one will be on Thursday, November 9th from 9 a.m. to 9:20. And the title will be Getting Paid Faster with Liens, Bonds, and Contracts. And then if you'll go to the next page for me.
Whoops, one too far.
Perfect. Once again, thank you so much for your time today, Chad. We really, really appreciate all the helpful information you provided us today. And I hope everyone has a sunny day. We hope to see you on our next webinar. Thanks so much, guys.